Good morning, everyone, and thank you for joining us today for our Workers' Compensation 101 webinar. I'm Allie Price of the Board's Stakeholder Engagement Unit. Joining me today is Joe Cavalcante, the Board's Advocate for Injured Workers. Today, Joe will cover the basics of the workers' compensation system, including employees' rights if they become injured or ill on the job, employees' benefits under workers' compensation, how to file a claim, how to get help with your claim if needed, information regarding COVID-19 claims, and tips and best practices for injured workers. We ask you to please keep your phone lines muted as we will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any that he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with your contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only we can see your questions and comments, so don't worry about everyone seeing your contact information, only we can access that. So with that, I will hand it over to Joe and we'll get started today.
Thank you very much, Allie, and hello, happy summer. Yes. It's summer, my friends. Hope everyone is staying cool and hydrated. So we are going to discuss the basics of the workers' comp system this morning. We are going to begin before there's ever an incident or a problem, because it's in everyone's interest to try and eliminate the incidents that hurt and harm people. So here is a very simple and free thing that you can do in your workplace, and you can also encourage others to do this. Why don't you form a labor management safety committee? We have some information on screen showing you some ways to do this. The point here is, let's talk to each other. Let's identify the places in the work sites where we all are that could cause an incident in the first place. And then let's mitigate and eliminate it as well as we can. You know, let's do some safety inspections. Let's get out of the conference room, get into the workplace. Let's review the equipment we use. Let's make sure we are, let's make sure that it's maintained properly and that we're using it according to the manufacturer's specifications. Let's check our procedures and make sure that our procedures are as safe as they ought to be or could be. Let's check our training. Are we training for the safest environment that we can have? You know, all these very simple, what sound like common sense things that maybe sometimes we don't all do. Let's try this. I can tell you, we have a labor management safety committee in our agency. All right, so let's get into the system itself now. Workers' compensation is a no-fault insurance system. No-fault insurance system, similar to auto insurance in the state of New York, to the extent that we're not looking to put blame for an incident on a party. We're not. Okay, so that's not a factor. Also, it's an insurance system. So that means somewhere in the mix here, we're going to have an insurance payer, and we're going to speak about that in a lot of detail in a few moments. The employer has to provide this coverage for workers. So it's the responsibility of the employer to provide this insurance, and they can do it in two ways, self-insurance or buy a policy. We'll talk about that in a moment. The important thing right now is the employees do not directly contribute to the cost of this insurance. This is a worker's right. That means workers, you cannot sign this away, you cannot negotiate it away, and as a matter of fact, you can think of the benefits that we're going to discuss this morning as a floor or a minimum, which means you can negotiate a richer benefit, but these are the minimum benefits. Immigration status of the worker is not a factor. This is one of the few places in this complex system where I can make a broad and categorical statement. Immigration status not a factor. Language assistance services are available, though. That means that in this system, if a worker wishes to speak a language other than English, the board, our employer, can help out. We're showing you right now the website, our website, and these are the languages that we have materials readily available in already. So there are about a dozen here, and over 90% of all New Yorkers speak one of these dozen languages, so more than 9 out of 10 we can help immediately. But we also have interpretation services available for workers for free. Just tell us, and we will get an interpreter to interpret into the language you choose. The Workers' Comp Board. This is Allie's employer and mine. And there are about 1,000 of us all across the great state of New York in almost 24 offices and hearing points. What do? Well, we regulate the workers' comp system. We do not pay the claims unless, okay, spoiler alert, if the employer didn't carry insurance, we'll front the money. We're going to talk about that in a few minutes. But we regulate the system through this very simple fact that we're supposed to get a copy of everything that happens, particularly the medical reports and bills, which are so important in this system, and also the records of payment and other documents. That's why I'm always very excited when healthcare providers join our webinars, and we do have a good few of them on this one. Hello, including one, I looked it up last night. There's a healthcare provider on this webinar who is from an office that is 1 street over from where I was born.
Wow.
I'm not going to say who it is, but yes, it is. So hello. Thank you for joining us because the healthcare providers play such an important role in our system. There are no claims without healthcare providers. So we get those records, and we also will hold hearings when it's appropriate to move a claim forward or to adjudicate said claim. Now, there's also this office known as the Office of the Advocate for Injured Workers. Yeah, I'm from that office. I'm the manager of that office. That's my title, Advocate for Injured Workers. My civil service title is actually Ombudsman. Now, an ombudsman, or an ombuds, as we're known, is a role that's in certain types of organizations that is there to ensure that the system is functioning properly. So that's what I do. I'm concerned with the health of the comp system, the sanctity of the comp system, are benefits being provided as they ought to, is the system functioning in the way it ought to function. And as part of that, we help workers with the more difficult and complex claims. We are also involved with fatality claims. We'll get to that. And I am also the board's liaison to the 9/11 community because, my friends, if you don't know, this situation is ongoing. People are still sick and suffering as a result of September 11, 2001. So on screen, we're showing you for a moment here, we feel it's important to point out that there are 3 different assistance programs that you may or may not know about. On the left, you see WTC Health Program. The federal government is funding these World Trade Center health programs across New York, and also they're also in Jersey and Connecticut, but then they go national. And these are health programs for people who were impacted by the attacks and the aftermath. So if that is you, would you please join one of these health programs and at a minimum go for the monitoring, okay? You're getting expert health monitoring. The second, September 11 Victim Compensation Fund, that is administered by the Federal Department of Justice, and that fund provides compensation to people who were harmed by the attacks or in the aftermath. You have to apply directly to them for these benefits, but, you know, again, I'm encouraging you and making you aware of these things. Finally, on the right, you see this World Trade Center Volunteer Fund? That's something that the board administers. That's because, obviously, the paid employees who responded, yes, they're, you know, depending on how it shakes out, they're in our system or they're in another system. Like if you're a federal employee, you're in the federal system. But, you know, you worked on a demolition team, you're in our system. Okay, but well over 1,000 people volunteered after the buildings fell. And those folks are in our system as volunteers. This is the only instance where volunteers can get a workers' comp type benefit. So we're just calling it out to them that those folks are included as well. And of course, to accomplish all of this, I have to report directly to the chair of the agency. All right, who pays your workers' comp claim? Remember I said it was an insurance-based system? That means there's an insurer somewhere in the mix. Here's how that goes. The employer can arrange this insurance one of two ways. They can buy a policy, and there are a good 260, 280 insurance companies who are licensed to write comp insurance in New York State, so they could just buy a policy. Incidentally, the biggest of them all is called the New York State Insurance Fund, NYSIF, NYSIF, SIF, the fund. Those are all the nicknames. I'm just calling them out because not only are they by far the largest, I think they might even be the largest individual insurer in America for comp, actually. I think I read that. But I'm calling it out because that's not us. Sometimes people confuse us because we're NYSWCB, they're NYSIF. We're not the same. They're an insurer. That's one way an employer can do the insurance is buy policy. The other way is the employer can self-insure. Now, when an employer self-insures, that means the employer has the financial resources available to pay the claims out of its own resources. So how do they do this? Well, they typically will hire a claim administrator, also known as a third-party administrator, also known as a TPA, in a system that loves acronyms and initials. I like to explain them to you, but I'm not going to use them. So they're hiring this claim administrator when they're self-insured to actually handle the claims. Here's what that means to workers. Your supervisor, your manager, your human resource department, they will have no idea what's going on in your claim. They're not involved. The moment there's an incident, the responsibility and the decisions are going to be made by either the insurance company, if they bought a policy, or the claim administrator, if they're self-insured in that way. Finally, last bullet on screen here, let's say the employer has not made any provision for insurance. Well, that's a naughty employer, and they're going to get some pretty significant penalties. The board will advance the payments. So your claim will be considered just like every other claim, and the same benefits are available. It's just that the board is going to be essentially advancing the money, and then we bill the owner of the scofflaw business personally. So you don't need to worry about that. Just please hear me saying, you got injured at work, file a claim. Don't worry that they didn't carry insurance. We will sort it out. Who needs this insurance coverage? Because I have been talking about this need to carry it. Well, let's think of the world in terms of for-profit and not-for-profit. A business, and when we say business, we're implying it's a for-profit endeavor. Otherwise, we'd call it a nonprofit business. But a business that's a for-profit endeavor who has employees is required to have coverage. A nonprofit who has employees could very well also have to provide the coverage. Now, let's take a look and drill down a little bit into who's an employee. What's an employee? Because you notice we're talking about employees. All right. You're a business. You're for profit. You have one employee, you need coverage. End of story. Sorry, it's another categorical statement. You have employees, you need coverage. Even if the employee is your niece and she's part-time, 10 hours a week for the summer, yeah, you really do need a policy. Nonprofit world, okay. In the nonprofit world, if the individual is compensated, that individual could be determined as needing to be covered as well. There's a standard that involves something called manual labor, and manual labor has a much broader definition in this law than you might expect. So essentially, we're going to say you very possibly might need the coverage as a nonprofit. The limited exceptions we can call out would be clergy and teachers in a 501c3. Okay, there's a high definition, there's a high probability that you're going to need the coverage. It's going to depend on whether you're an employee, and this does include internet businesses. This does include, you know, rideshare and people that you hire who get dispatched by an internet business. Yeah, it does include that because there are some very, very popular, well-known ride-sharing apps and businesses, by the way, who are carrying comp insurance. So if that's you and you get harmed, I should talk for just a moment more about who's an employee. How do we determine who an employee is? Okay, here's the operative question. I'm talking about employees. How do we determine you're an employee? What's the difference between an employee and an independent contractor? Independent contractor is one of those terms that the public uses all the time, and it has a specific meaning in our system, so here it is. In the workers' comp system, an employee is determined by the level of direction and control that the prospective employer is exercising. Direction and control. There's actually a test that has at least 10 criteria in it. So the point is, if the employer is exercising direction and control over the activities of the worker, then that worker could be considered an employee for comp purposes. So just because the worker is being paid on a 1099 in and of itself does not say independent contractor. It just says the worker is being paid on a 1099. Now, that could be a factor that tilts it one way or another, but I'm just mentioning this because I just want you to understand that I can think of at least 5 different government entities that are concerned with independent contractor status, and we all use our own law, and we all use our own criteria. So you could be an independent contractor for tax purposes. You know, the IRS or New York State Tax and Finance might consider you an independent contractor, but you might not be considered an independent contractor for workers' comp purposes. We make that decision as needed. All right, new topic. What do you do if there's an incident? Well, you're a worker. Number 1, get the necessary medical treatment promptly. Please go get medical care. You do not need to use an authorized comp provider in an emergency or what they call an emergent situation. No, just get the best care you can as quickly as you can, please. If you're an employer and you want to help the worker get to an urgent care, thank you. You do not have to direct the worker to a particular urgent care. And I'm going to say something with peace and love right now. I've been hearing about people going into the exam room with the worker as if they have a particular right to be there. just want to remind everyone that that's the workers' call, and that falls under health law. That's not a comp thing. Okay, there is a certain sanctity in the exam room. So just want to mention that in the most collegial way I can, because, you know, as ombuds, I really do get complaints about these different types of behaviors. Okay, so now you've got your treatment workers. You should be telling your employer in writing about the incident as soon as possible. This is a key step in the process. In order for the workers' comp claim to begin, well, number one, you need to care, and you need to tell the provider that this happened at work. If it happened at work, or if it's attributable to work, go ahead and tell the provider. And then you have to tell your employer, because your employer now by law has to tell the payer, and the payer has to make a filing with the board. That's going to begin the claim. That starts the whole process now. So be sure to do that. And when we say in writing, you can use an email. Email's great because it has an audit trail, it has dates and so forth. You can use a document. You technically can send a text. I just don't recommend it. I don't recommend it because I dare you to go on your phone and find a text that you sent 11 months ago to somebody. Okay, because you might have to show it at some point. So it's possible, but you don't have to. You can file a claim form known as the C3. You can get this claim form from us, or you can do it electronically. Electronic is quickest, cleanest, easiest, but if for some reason it doesn't work for you, that's okay. Do the paper. Workers can always submit paper, okay? We sometimes ask professionals not to submit paper, but workers, you're always allowed to send paper to us. Don't worry about it. So this is what the claim form starts to look like. You see those tabs there? So you'll just fill in what you need to. The ones with the red asterisk are mandatory, I do believe. And once you do that, okay, you filed the notice, you told the doctor it's employment or work related, they'll send their forms in, you're going to now have a complete claim. Keep getting your treatment. Workers, you have 2 years from incident to file the C3. Okay? You have 2 dates to be conscious of. The first date, tell the employer in writing, you should do it within 30 days, but if you're doing it on day 40 or day 70, just do it, okay? Don't worry about that. Let us worry about that. The big one is you have 2 years to file a C3. Now, you know, if the employer files and your claim starts on day 12, fine, your claim is started. Okay, you don't need to file a C3 unless somebody asks you to. But just want you to get this date in your consciousness. 2 years after incident to file and to start the claim. And now, a word from Allie.
All right, so we have a poll here for you. So this is a scenario. Should Kadir file a claim? Let me get the poll going for you. All right, so Kadir is not an American citizen and is in the U.S. on a work visa. Kadir works 40 hours a week on site at a software company at an assigned desk using the company's equipment on tasks the company assigns. Kadir is paid on a 1099, so the software firm considers him an independent contractor. One day, Kadir is inattentive and drops a computer server. It fractures his leg. The employer calls an ambulance that takes Kadir to the hospital. So, yes or no, should Kadir file a claim? All right, looks like got answers trickling in. Quite a few are saying yes.
Okay, people, we're going to give you a moment. We love to see at least 50% participation.
Yes, yes, we love it. Okay, we're still seeing a lot of yeses, Joe.
Good.
All right, all right. Can we get a few more responses? Oh, okay. Got some people in progress. We'll let it go for another few seconds.
Yes. Should Kadir file a claim based on this incident where he was inattentive and dropped a computer server and
We're at half.
fractured a leg?
Yes. We're at half. So what do we think? We're looking at almost all yeses here.
Right. We see one person who's indicating no. So it's one against the crowd. That one person, if that one person wants to explain in the chat why that one person thinks not, please do feel free to share that thinking with us. If you send it to the panel, we're the only ones who are going to see it. But yes, we do think Kadir should file a claim in this instance. Remember, filing a claim. We're not saying Kadir is going to be paid, but we do think that this claim ought to be considered, yes. And you did not fall for any of the various red herrings that we put in there, like about citizenship and inattentive and paid on a 1099. So, oh, do we have some logic here? What's the logic here?
Assigned desk.
Well, that would indicate, okay, I'm sorry, everyone. We're reading the comments that are coming in. We're looking for why someone thinks no. Yes, the person with the assigned desk is agreeing with us. Right, because the employer assigned a desk, which is indicating a level of direction and control. Okay, so yeah, file the claim. And this is a good place to make the point that you can file a claim and it's okay. Even if your claim's disallowed, it's okay. As long as you're truthful on your claim, there's no penalty. Let's now begin talking about the benefits. So the benefits are the medical care, the lost wages, and then the fatality benefit. So first, we're going to do the medical benefit. This is a very important point now. The medical benefits are provided at no cost to the worker for their established illness or injury for life. It is a lifetime benefit. Very important concept. So providers, you don't need to contact about reopening claims if it's just a claim that's been there for a while. And insurers, you know as well as anybody that this is a lifetime benefit, so the worker doesn't need to take any special step. So workers, it's a lifetime benefit. All the expenses for medical care we're talking about are covered, such as your tests and hospital visits, inpatient, outpatient, office visits, the medicine, the pharmaceuticals, PT, physical therapy, etc. There's another benefit to this, and that is travel reimbursement. So workers, you have to travel for care? Well, there's a benefit to pay you back for that care. For that travel to care. You can't file this to go to the pharmacy and pick up your meds. I'm sorry, it's not applicable in that sense. But if you have to see a physician or a physical therapist or go to the hospital and so forth, you're going to file Form C-257. It's really this simple. Nature of expense. That's who did you see? Date. On what date? Amount. Well, you can indicate, if you took a bus, you can indicate the cost or a subway, or if you drove, you can get the mileage and use the mileage rate in effect at that time. Like, for example, the mileage rate right now I think is 67 cents a mile. So if you drove 10 miles, look at that, that's $6.70. You just put it on that form. Okay, so there's no time limit. So you can go back in time. There's no time limit. Major advice coming here, my friends. Number one, let's go to the easier part. When you go for treatment, workers, give your providers a fighting chance here. Show up with your WCB case number. Those are the 8 characters we assigned. Probably starts with the letter G, like gorgeous, if it's from the last 15 years. If you're a volunteer firefighter, it's going to start with the letters FA. And if you're an ambulance driver, we'll start with the letters AA, and then you'll get six numbers. Okay, so important point is we're going to give you a case number. Please give it to the provider. Give the provider the name of the insurance payer. And then finally, the insurance payer is going to assign its own case number. Fine. Just give that to the provider, please. All right. Now, I would like to spend a moment here on what we call the degree of disability. This is a topic that we spend a lot of time on in the Workers' Comp 202, our second level class, which you're welcome to take. We did one yesterday. We'll have another one in August. Just watch for the announcement. But workers, here's a very important thing. All injuries are temporary unless they then become permanent. So everything's starting temporary. So if you're in temporary world and you're getting payments, that's what we call payments of ongoing disability. As you see on the first bullet there, you need to see your treating provider every 90 days minimum, because the treating provider has to indicate how disabled you are. That is the second bullet. Understand your degree of disability. Your degree of disability is how disabled you are. It's going to be a percentage between 0% and 100%. Understand it. Make sure you see that treating provider every 90 days if you have some disability. If you're at 0%, you don't necessarily need to go every 90 days. You're just going to go as needed for treatment. But if you have 100% disability, that means you can't work, 50%, 75%, you're eligible for a payment. You need to go to that provider every 90 days and find out how disabled you are, because the insurance payer can't do the math to create the amount of money you're supposed to be receiving if we don't have a degree of disability. Here's a best practice. You might be asked to go to an independent medical exam. This is when the insurer hires a physician, and it's almost always a physician, unless if it's psychological, you might go to a psychologist. But this is when they hire a probably physician to assess some aspect of your claim, how disabled you are, whether you're as well as you're ever going to get, etc. So here's what you need to know. Number one, no doctor-patient relationship. That doctor's not treating you. None of the privacy that you expect at a healthcare appointment is going to prevail here. Anything you say can be put into the report. Number two, you may bring a witness. It's that simple. You're allowed to bring a witness. No one can tell you no. Anybody tells you no, just say, I'm sorry, Joe said I can bring the witness, and go on ahead with your witness. You may record the exam. You can record the whole encounter if you really wish, but you can certainly record the exam. Your witness can do it. Video and audio, you don't have to give advance notice. You might do that because you're going to get a copy of the report. That's bullet number 3. You should probably review that report. If you have an attorney, your attorney's definitely going to review it. And you really want to make sure that you understand where anything in the report is coming from. You might want to double check the findings in the report with the video and audio you made to make sure you can see where it's coming from. If you have an attorney and you don't see where the finding's coming from, your attorney's going to take a good look at it, and since they're far more knowledgeable about these topics, they might see where it's coming from, or they might not. So, if they don't, if you don't, or if you have a complaint about the conduct of the examiner, you can make that conduct to my office. We're going to give you the contact info at the end. You can make the complaint to my office. I will review it, and the probability is extremely high that I'll pass it on to the IME committee for review because we take these extremely seriously. Now, just want to note, I said conduct. If your doctor says you're 100% disabled and this IME says you're 0% disabled, that's not conduct. That's a difference of opinion that has to be litigated. But conduct has to do with discrepancies in reports or how you were treated there. Were you treated in a professional manner? Were you examined in a medical facility? I only say that because before we got very serious about this decades ago, people used to get examined in hotel rooms. Yes, so the regulations and the laws were changed to reflect the fact that they have to be examined in medical type facilities. So, you know, if that's not happening, you need to tell us. And finally, you can claim the travel reimbursement for these IME exams, and sometimes you have to go great distances. So it's Form C-257. Let's turn now to the cash benefit, or what we call in our system the indemnity benefit. If you ever hear the word indemnity, we're talking about money payments. We're going to begin with how much were you earning? That's called the average weekly wage. We look back 52 weeks or a year from when you had your incident and calculate how much you earned on average. And then the maximum benefit is going to be 2/3 of that amount. That's your maximum, up to a limit. Now, all compensation counts. Your overtime counts, your bonuses count, your meal allowances, your free apartment because you're superintendent of a building in the Bronx. You get a free apartment. That apartment has a value, as you well know. You need to tell us what you're getting. The maximum rate you can receive as of next week, July 1, is on screen there, $11.7146 per week. It's a weekly benefit, and you're going to get your check every 2 weeks. So that's just a little paradox, but you just need to understand, okay? It's calculated on a weekly basis, get paid every 2 weeks. That's the max you can get. It's tax-free, okay? There are no taxes at all taken from it, or you don't need a 1099. Every January, we get a couple inquiries, people looking for 1099s, right? Allie gets them too in the outreach mailbox. We get them in my office. No taxes. The minimum is $275 a week, okay? Now, the minimum is an interesting little thing. Just want you to understand it. That's the current minimum for any injuries that occur in 2024. 2023, we had a $150 minimum, okay? So no, I'm terribly sorry to say that if you're getting $150 a week for an injury that happened in 2020, no, I'm sorry, you're not getting boosted up. That is per incident year. So as of January 1st, it's going to go up to $325 a week for any accidents that happen in 25. And then in 26, it's going to get indexed to 1/5 of the state's average weekly wage. Here's just a moment on what is indexing, because you hear this term in other systems as well as ours. We now index in our system. So that means the Department of Labor every year calculates what the average payroll for the average New Yorker was for the previous year. So for our purposes, we adjust our maximum benefit every July 1 to reflect 2/3 of the average New York payroll from the previous year. If you do all the math, you will see that the average New York payroll last year was about $89,000 a year. That's what the average New Yorker was earning. Now, it's an average, my friends, so that means if you're a worker, this is when you're very happy you have Wall Street in your state, and you have the Knicks, the Nets, and the Yankees in your state, because all those high earners obviously push up the average. So that's why the minimum as of July 1, 26, in 2 years, that's going to be indexed to a fifth of the average weekly wage. And in all instances, if the worker was earning less, they would get their full wages. Lost wages, okay, here are the types of lost wage benefits. First, let's do the easiest one to explain is the Schedule Loss of Use Award, which is, it's a special type of a benefit if you injure a limb and you never get 100% use of your limb back. There's a benefit for that. It's called the Schedule Loss of Use. So if you're a worker and you injured a limb 5 years ago and nobody ever talked to you about an SLU, Schedule Loss of Use, and you didn't get 100% back, talk to somebody. Go to your doctor. Find out if you lost any use. On the other hand, here's how the benefits work. Remember I said everything is temporary until it's permanent? Okay, so you have temporary benefits. It's temporary partial, temporary total. You're partially injured, you're totally disabled, okay? Then you're either going to heal 100%, that's great, love it. Or sometimes, unfortunately, you end up having a permanent injury. So you're going to have a permanent partial or permanent total injury. We go through these distinctions in great detail in the 202, if you want to take that. But the important point is there is a lost wage benefit, and you can definitely get more info on our website, wcb.ny.gov. You can get more info on the SLU, Schedule Loss of Use benefit. There's a pamphlet on that. We have a ton of pamphlets on a ton of topics. That's what Allie Price is specializing in. Best practices for payments. Okay, this is something, Allie's heard me say this, and I'm going to say it again because I can't say it too much. My friends, if you can have a bank account and you're getting payments, will you please sign up for direct deposit? I don't understand why you're not getting direct deposit. If you have a bank account, would you please sign up for direct deposit? Also, if you're getting paid in cash, that's fine. Cash is still legal tender. Keep some records. Get yourself a notebook. Open up an electronic file on your favorite device. Start recording who paid you, how much, when, for doing what. Because you might need those records one day, like if, for example, you have a workers' comp claim. There is another benefit that we're going to speak about for a moment called the fatality benefit. So if a worker should perish on the job or due to employment, there's a benefit. We are showing you here the top of a piece of public communication we wrote called Filing a Fatality Claim, okay? This explains the benefits, which I'm going to explain now. Okay, for example, funeral and memorial expenses. That's the first benefit. In the classic New York metro region definition, we're talking New York City, Long Island, Westchester, Rockland. Up to $12,500 is reimbursable for funeral and memorial expenses. The rest of New York State counties, $10,500. Now, what's the benefit? Well, it's paid like the lost time benefit, and it's going to go to the surviving family first, as in we look for a lawfully wed spouse first. The gender is irrelevant. If there is a spouse, or if there's not, now we look for children of the deceased. Okay? They have to be formal legal children of the deceased. They're going to be able to share in the benefit with spouse if there's a spouse, or not if there's no spouse. They'll get the whole benefit. They'll share the kids up to age 18 or up to 23 if they're enrolled in an institution of higher education. And then we also are looking for blind and disabled dependents of the deceased, blind or disabled, I ought to say. Those folks, blind or disabled, can get the benefit for life. Now, if none of those parties exist, $50,000 is payable to the parents of the deceased. If they don't exist either, $50,000 is payable to the estate. That means we're dealing with an executor or an executrix. If there is a distant family member, that person has to deal with the estate. Finally, there are two nonprofits that we call out to your attention just because they're nonprofits who are doing what at least this advocate considers as good work. Kids Chance. Kids Chance is a national nonprofit that has a chapter in each state that will provide a benefit for the children of New York's fatally or seriously injured workers. They give scholarships. I know for a fact they have scholarship money available to award, and it's June. The bills for college are coming. You know, college starts in August. If this is you or someone you know, check them out. Also check out the Triangle Shirtwaist Factory Fire Memorial. This is another nonprofit that we also bring to your attention because they also have scholarships available for children of workers who perished or were grievously injured. Okay, we really recommend that you check them out. Okay, you can see the contact info there. COVID-19, yes. COVID-19 is an infectious disease. Infectious diseases are payable in the comp system. It's that simple, my friend. Doesn't matter what the status is, pandemic, not pandemic, whatever. Doesn't matter. It's an infectious disease. Lyme disease is an infectious disease. That's payable too. Okay? It's that simple. The medical reports are going to be key here. Number one, you're going to have to demonstrate you had COVID. So there's the positive PCR test. Okay, you can still get those, I'm pretty sure. Get one and file it. If you don't have a positive PCR test, you're going to need a healthcare provider to establish that you had COVID by virtue of diagnosis. So then the question is going to be, did you contract COVID due to your employment? Well, again, we're going to start with the provider's opinion. So why don't you tell your provider all the details? Okay, did you have public contact? Did you have a lot of contact with the public or with your coworkers? Did you all wear masks? If you didn't. If you did, tell the provider, because that's a fact that the provider is going to want to consider in assessing whether the probability is that you contracted COVID due to employment. Because we use probability. Nobody can tell a moment in time when you might have been infected. So that's why we use the probability that you were infected due to employment. Was COVID-19 prevalent in your workplace? Was there an outbreak in your workplace? Do you work in an office of 12 people and 6 of them had COVID the same week, including you? Why don't you tell your provider about that? Because you don't have to get it from a paying customer. You could get it from a coworker. We have a fact sheet. We do have a short video available online. We still have our COVID page up and running, so do check it out. It's pretty easy to get to off of our main page as well. I think Allie is going to come back and give you another quiz.
Yes. All right. So we have another poll for you, another yes or no. So I'm going to open the poll now. So yes or no, should Liz file a claim for COVID exposure? Liz worked at a big box store in the seasonal department during the holidays dealing with the public. Liz fell ill and called in sick to work. Her PCR test was positive. Liz received paid sick leave for missing 2 weeks of work. Several of Liz's coworkers also had COVID at the same time. Should Liz file a claim for COVID exposure? Yes or no? Okay. Getting some yeses, one no, but a lot of yeses so far.
We have this lovely graphic that we see on screen, which is all in colors, and, you know, how many yeses, how many no, how many people have given us an opinion. It's quite attractive, actually.
Yeah.
And we're almost at the halfway
We're
mark.
almost at half. Can we get a couple more answers? What do we think? Yes or no? Should Liz file a claim?
We've passed half.
We've passed half, okay. So what is the answer, Joe?
We think that Liz ought to file a claim for COVID, and one of us has indicated no. So again, if you'd like to explain your thinking, please do in the chat. We'd love to see it. But yeah, we do think that Liz should file a claim, and we can tell you from experience, because we've done this, I don't know, once or 50 times already in the past. People tend to think, why would Liz file a claim? Because she already got the paid sick leave. You know, that benefit under paid family leave or under state, the paid sick leave, you can get paid for the time you missed. Okay, here's why we think she should file a claim. Even though she's not missing any money, do you remember how I indicated that we use probability and how workers' comp claims are a lifetime benefit for medical care? Well, that's pretty important because Liz could have a problem next year or 5 years from now. She could have, unfortunately, something called long COVID. So once you establish the claim, you do have this medical care available to you for life. We have a couple of questions coming in on this, which is really good to see. Someone wants to know, what form do you submit for COVID? And you're going to file a claim. There's no distinction in that matter. So you're going to be filing a claim. Someone's asking, do we consider the prevalence in the community or only the probability? You're actually elucidating the same principle there. How prevalent it is going to indicate the probability, and we're also going to be focusing in on, you know, the particular activities of the worker. So in this question here, prevalence in community, remember it's workers' comp, so I think I see what you're getting at. It is possible that we could get COVID from our community involvement and not necessarily our work involvement, and the comp is for the work involvement. So, you know, we do just try and consider, you know, everything. Do we have any, is that it? Okay, I think we were able to address all your COVID questions. So, thanks everyone. We're getting towards the end now. So just want to acquaint you with some other ideas. There are penalties possible for late payment. Remember I said tell your employer so they can tell their insurance payer so we can start your claim? That's because if you're missing time, the benefit payment should start within 18 days of the incident. So, or 10 days from notice, whichever's later. So that's why you need to tell somebody to get this process started. Also, if you get a decision from a judge, there's going to be a filing date on that decision in the lower right-hand corner. Benefits should be paid within 10 days of that filing decision. If you're set up for direct deposit, well, you'll get your deposit within 10 days of that decision. If you're not, or, you know, you're going to have to get a postmark within 10 days of that decision. Also, interest can be due with after an appeal, so payers, please be sure to calculate that interest payment. Now, you're a worker, you do have some responsibilities here. You should try to come back to work as soon as you're physically capable. Enlightened employers will have return to work programs. They'll be able to take you back if you have like a, you know, a small amount of disability. They might put you on what's called transitional duty, as in, okay, you can't quite do your regular position, but you can do something else and make a contribution. So you come back, you go back on the payroll, and you're making a contribution. And employers, this is why we say enlightened employers, if you bring the worker back, then there's no comp benefit that's being paid, so you've now removed that experience from your premium calculations for next year. Yes. Try and understand any agreements you make. Try and ask questions of your representatives. And please, if you're a worker, consider signing up for eCase. Oh my gosh. Did you know that there's this resource called eCase wherein you can see all the documents in your file, just like we all do, like those of us who are allowed to. Okay, so there's the button. You click that, you register for eCase, and this is how easy it is. This is all you need to do, is submit that. And I think you get your access maybe the next day, 24 hours, yeah. So seriously, consider doing this. All right, our last topic, which we're going to go through pretty quickly now, is what do you do if there's a hearing? Okay, well, you or your rep should attend. If you don't have a rep, you need to go. I would please recommend you go, even if you have a representative, but definitely follow your representative's advice. Pay attention to whatever questions the judge asks you to, but you can go because the insurance company is definitely going to send its attorney or the claim administrator. You can have an attorney represent you. That is perfectly fine, and sometimes that is like indispensably important to have an attorney representing you. All of our hearings right now are virtual. They're not being done in person yet. We'll talk about more about that in a moment. You could have some witnesses, depositions. The board does not use the formal rules of evidence and procedure that courts use because we don't really operate courts technically either. So it's not like you see on TV. It's not like Law and Order. There's no bailiff. But, you know, we do use the rules of decorum, and it's a slightly less formal, but still a place where decorum does prevail. And as I was saying, right now, it's going to be a virtual hearing. We will be holding in-person hearings again in the autumn. So keep watching for our announcements. But the virtual hearing that has kept us running all this time, we didn't lose any hearings due to the pandemic. We're very proud of that. This is essentially a teleconference, so you can use an app if you want. You can get it from Apple or Google, or when you get your hearing notice, we'll have the web page and the directions and your password on it to get in through that way. If you have a device with a camera and a microphone, you're all set. If you need to telephone, if you want to participate by telephone and not use the camera and the microphone and so forth, that's fine. You just need to tell us by, let's say, 9 a.m., let's say before 9 a.m., because we hold some 9 a.m. hearings. The morning of the hearing, you need to tell us by that morning at the latest. First thing in the morning, phone's open at 8:30. You're calling at 8:30. You'll get through, don't worry. You need to tell us you're going by phone because the judge calls you. The judge calls you. You don't call, your lawyer doesn't call you, the judge calls you. But yes, definitely do join your own hearing. Here's our social media. Here is where, Allie, I think people have been asking, is this recorded?
Yep. So for the couple people that asked, all of these sessions are recorded and uploaded to our YouTube channel, and we will communicate with you when those are up there so you can rewatch anything you missed or just rewatch in general. But yes, YouTube channel is great resource for all this stuff.
Wonderful. Encourage you to follow us as you wish. And then if you want more information from my office, here's our contact info. There's our phone, there's our email. Don't be surprised if you email us and we answer you in 5 minutes. because that absolutely happens, and I see all the emails, so I know what's happening. And then if you want to see our page, we have a page on our website. Remember websites, people? Remember them? Well, we have a pretty darn good one. And if you want to see our page, just put Advocate for Injured Workers in the search bar, and you'll go right to it. We have all kinds of great info there, including some videos and everything else. And you can pose your questions there, too. People do take advantage of that. We do get emails. The subject line says, Ask the Advocate. So we do get several of those a day. So that tells me they're coming from that webpage. So thank you. So as of right now, I think it's question time.
It's question time. So we got questions throughout the presentation that we'll start addressing now, but if you have any more, start putting them into the chat and we will address them as we go. All right. All right, first question we have is it fatal to a workers' comp claim if the employee fails to inform the employer in writing of the injury within 30 days of the injury-causing event?
Maybe, maybe not. There are absolutely conditions and reasons why this or that might happen. So no, that is not like an automatic disqualification because everything depends on your facts. And if you're a worker, I would not disqualify myself. File the claim. For example, here's a situation that happens a lot. You wake up in the morning, can't get out of bed. Your back is in that much pain. You think about it. You think it's related to something that happened yesterday, or the day before, or the week before, or 2 weeks ago. So what's the incident date? Okay, so don't disqualify yourself. Just file your claim. We have a very complicated question that has come in with respect to self-funded workers' comp plan. First of all, there's no distinction for benefits between self-funded workers' comp plans and policies. However, our inquirer is writing about questions related to what I think are probably third-party actions. So, for that question, my friend, I'm going to suggest you pose that question directly to the Office of General Counsel. You can email these very serious legal type questions to General Counsel's office. I'm going to suggest you do that. Get the address off the web page. I'm sorry, I don't know if it's Office of General Counsel at WCB or if it's shorter, but definitely do that. And Allie, I think that this is going to prevail for the Section 32 question as well. So sorry, guys, but that's just how that goes. But I guess as a general concept, just as a general concept, if you have a very legal type question, you can email our Office of General Counsel, and they'll answer it.
Doesn't the injured party have to have been engaged in some medical care associated to the injury at least every 3 to 4 years? Isn't the claim closed if they do not seek treatment within that time period?
Nope. 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 And nope. Once established, yeah. Listen, individual payers might create their own rules internally. That's great. Just please don't project those rules onto workers. Just please don't project those internal rules onto providers. If you need to do something special internally because you haven't seen a medical in 4 years, go on ahead. Fine. Whatever you need to do to deliver those benefits. So, no. I'm sorry. It's a lifetime benefit. Please don't stand in the way of the worker getting treatment, and please don't ever tell a provider This claim is closed if there's no Section 32 in the file. That'll get you a complaint, okay? The only reason I'm saying this is because it's happened, and it does happen, and it's not the way the system works. Yeah, go ahead.
All right, so next question is, can you suggest references for providers to better understand the degree of disability? I attended yesterday's 202 session. My providers would like to get direction as to where to go for references on the percentages of degree of disability.
All right, thank you. We have an RN who's participating. Love to see that and hear that. We hold webinars directly focused at providers regarding these questions. So I'm not a medical provider or have any expertise with respect to medicine in any way. So I can't answer that specifically, but you're only asking for the resources. So join one of those webinars, come to our website, and when you get to our website, you're going to see 6 different blocks. Worker, employer, payer, provider is one of them. Click the provider block, and now you're getting into all of our provider resources. We do have a number of resources directly for providers on that topic. So I support you. I'm glad you asked that question. Go to the website, and then also I can do a little business for the medical director's office too. I've promoted general counsel. Now I'm going to promote the medical director's office. You can you can write them at MDO, at wcb.ny.gov, or you can phone them. The phone number's on our website. I think it's 800-781-2657, but don't quote it. Look that one up. Okay, so yes, they are willing to talk to you, and you can probably even get a training if you really need to.
To the individual who asked or told us that the website's not working for COVID, try it again with COVID lowercase, and it might be case sensitive in that instance, and if it still has a problem, we are working on it. Thank you.
Yeah. Okay. What form do you submit?
Yep, we're going. Next question is, can employers register for eCase to manage the third-party administrator?
Employers have access to the claim folder. You don't have to go through eCase. Well, you don't register the same way the workers do, but you have access to that claim folder because you are what is called a party of interest. Parties of interest are folks who have to have access to the document. Hey, somebody said that's awesome. Okay, so thank you very much.
All right, next question is, I have an IME complaint for fraud. How can I file the complaint for review with this office?
Okay, number one, have you ever complained about it before? Have you ever filed it before? If not, well, you see that email address on screen? Write it up, send it to that address. I promise you, you will be acknowledged when you file it. I might even, because I'll be responding to you, I might even ask you some more questions. If you can be as precise and as detailed with respect to the complaint, okay? You don't have to go through the details of how you got injured, but if there are some relevant details to your complaint, that's what we're going to be interested in. Yeah. Oh.
All right, next question. Workers' comp is non-taxable, so if the person initially uses his sick time and got reimbursement, then employers should also be reimbursed the taxes deducted from him?
Okay, so this is a very mathematically based question. Here's how it goes. I'm just going to give you the answer, and then you're going to fit it around your details. Let's make it simple. Worker was out of work for 4 weeks. You have a 40-hour week. So that's 4 weeks times 40, that's 160 hours. You used 160 hours of sick time. So that means you got your full pay, okay? Now your claim gets established. You get 4 weeks of comp payments. Remember I said comp is 2/3? Comp is 2/3. So the sick time that's going to be restored is 2/3. So if the employer wants to still let the 1/3 sick time usage sit there, okay. So that means that you were held harmless, you're the worker, you got your full money. They don't have to, though. So now with respect to taxes and so forth, you have to sort it out. You have to sort that out. Someone wants to know what would save a claim if you didn't tell the employer within 30 days you had an incident. I can't answer that. Just please take away the message, don't preclude yourself. You had an incident, just file the claim, let us sort it out.
All right, next one. Can you be cut off benefits for not attending an IME, and if so, how and when?
This is a 202 concept, but you asked it, so here we go. Number 1, worker is invited to an IME, and when you're invited, you have to pretty much go unless. So you didn't go. Can the payer stop your payments? Yes and no. They cannot, they may not stop your payments if there is an order in place from a judge called a CCP, a Carrier to Continue Payments Order. If a judge has previously said on the record, the carrier or the insurance payer shall pay this amount of money per week, no, they can't stop your payments. Can they stop your payments if you do miss an IME and there's no CCP? Well, sometimes they do. And then you're going to have to call us, or you're going to have to get in front of a judge. It's one of those kind of gray areas, but sometimes it does happen. I wish that, the reason why you didn't go to the IME, I wish that everybody would pay attention to it, and give it some consideration, but it is possible it might happen. Do we have anything else going on, Allie?
Got this.
Okay.
Yeah. All right, next question. What happens if a claimant moves and the board cannot reach them? Will they be cut off? And if so, how can they resume benefits once they contact the board?
All right, so a claimant or an injured worker moves. The board cannot reach that injured worker. Will they cut off the benefits? Well, remember I said the board doesn't pay the benefits? So why would the board stop your benefits? So the answer is no. If you moved, yes, it's on the slide. If you move or change your address, would you please tell us? Would you please tell the payer? So that's a really good practice. But no, just the fact that you moved doesn't mean your benefits should cease, and the board doesn't pay them anyway.
Alrighty, next question. Do I have to give full medical access to workers' compensation?
Oh, by the way, if you got direct deposit, it doesn't matter where you live. You're still getting your payments. All right, do I have to give full medical access to workers' compensation? That's a rather broad question. I think, I'm going to speculate for a moment, okay, just based on experience. Sometimes workers are asked by a judge to file a HIPAA form that gives access to records. If the judge asks you to do it, you should do it. If the judge asks you to do it and your lawyer says, let's appeal this, okay, appeal it. Go on ahead. But otherwise, that's where it might be. Now, if someone's asking you for access to everything and it's not a judge, you don't have to say yes. If the judge says it or the board says it, that's a different matter. Okay? So you do still have some rights in that, to that extent. To the person who the thing about the IME fraud, you can send it back to us. I'm pretty sure I know what's happening here. Just send it back in. Sometimes if you report a fraud, you don't get this vast report of what happened. I'm sorry that you don't. Okay, so the person, I thought I recognized your name. Go ahead, send it back in, and we'll take a look at it, and we'll tell you what happened.
All right. Is there a statute of limitations for a workers' compensation claim? Example, possible cancer related to work environment.
The 2 years. It's the 2-year thing. So that you have 2 years to file a claim. So that's your statute of limitations. When in this example, you've given the most complex possible example, which is fine. I'm sorry that someone might be suffering this, but it's fine if you give us the most complex. The reason I say that, possible cancer related to work environment. That's what we call an occupational disease. Occupational diseases are payable, but they are the most complex claims. So, don't preclude yourself. Get yourself a lawyer. And this is what I'm going to recommend a lawyer, and have the lawyer assess the situation. Regardless of what the lawyer thinks, if you still want to proceed with the claim, go on ahead and file it. Go on ahead.
Next question, if you were injured more than 25 years ago and received a diagnosis of partial disability then, can you receive medical treatment for that part of the body now?
Of course you can, because Allie, what have we been saying all seminar about your eligibility for medical care?
Lifetime treatment, right? For that injury or illness.
Yep, it's lifetime. So this is one of those categorical statements, yes.
Next is the 2 years from injury causing event no matter what, or when the employee knows or should have known that the injury was caused by the event on the job?
Good question. It's the latter. It's when the employee knows or should have known that the injury was caused by the job. Knows or should have known, yes. So this is why it gets complex with something like an occupational disease, because you might have worked there 20 years ago, but you just got diagnosed with something last week. And yes, and the other element of the advice prevails. See a lawyer. How do you see a lawyer? How do you find a lawyer in our system? Well, since we have no more questions, somebody wants to dash off a question real quick, go ahead. But otherwise, I'm closing with this little piece of info. You want a lawyer and you're an injured worker? You have 3 options. Number 1, call the New York State Bar Association. They'll give you some names. Number 2, call or use the web too, because everybody has a web page and an email. Use the Injured Workers Bar Association. That is a group of the attorneys who tend to represent injured workers, the Injured Workers Bar Association. They'll give you some names. You can also go to our website and look up licensed representatives. We do give an exam periodically. No, we don't have one scheduled right now, but we do give an exam periodically that members of the public who are expert in comp can take, and they can get a license to represent workers, even though they're not lawyers. Finally, to the person who's asking if this person should get a lawyer if your employer is private, whether your employer is private, public, or anything else is, I don't know how that's germane in any way. It's just a matter of, do you want a lawyer to represent you? And there are definitely instances in this system where hiring a lawyer is a really good idea. Occupational diseases, very complex claims, or maybe your claim is controverted, it's being formally disputed. That's a really good instance when you might want a lawyer.
All right, that looks like the last question, so I will begin wrapping it up here. All right, thank you everyone, and thank you to Joe for joining us today. Just a reminder, you can sign up to receive workers' compensation news, including information on future webinars such as 202, straight to your inbox. To sign up, visit the board's website at wcb.ny.gov, scroll down to the bottom of the homepage, and select Get WCB Notifications. We also distribute information via our social media channels that we mentioned before, so please follow us on Facebook, X, Instagram, and YouTube. We thank you all for joining us today and enjoy the rest of your afternoon.